Good afternoon. Today is November 4, 2024, and we are talking about ethics in New Jersey workers' compensation cases. Hi, everybody. My name is Greg Lois. I am the managing partner of LOIS Law Firm, and I'm going to talk to you today about ethics in New Jersey workers' compensation cases. And this is a new topic for us in our webinar series. As you might know, the webinar series is loosely based on the handbook that I write for the Matthew Bender Practice Guide series published by LexisNexis. Last year, for the first time, we added a new chapter on ethics and applying the rules of ethics to defending or prosecuting a workers' compensation case. And this is the first presentation that I'm giving based on the new chapter in our book and for this very interesting topic. And if you're thinking, wait, ethics isn't that interesting, that's my goal today, is to apply it to the kinds of common and practical things that we see in our cases every day. So jump on in and let's start talking about ethics. Quick reminder, this presentation, whether you're observing it live or recorded, is for instructional purposes only and is not legal advice as to any particular matter. My goals today are to talk a little bit about where the ethical rules come from and look at it from the perspective of petitioners and then respondents' attorneys. So first thing, where do these rules come from? Where do they, what are we talking about here? And in New Jersey, it's pretty straightforward. We do have rules of professional conduct, which are contained in the rules of court. And we also have administrative code provisions, which are the code provisions that apply to workers' compensation cases, 12:235 et sec. So there are some rules and requirements in there that I'll talk about today. Ethics opinions, of course, from the New Jersey Supreme Court Advisory Committee, which explain or apply the rules of professional conduct, which are again contained in the rules of court. And they publish these ethics opinions on all different topics. And I think they're interesting to utilize as a resource because they are really give you a statement of facts and then apply the ethical rules. So let's dive in and let's start with the ethical issues that are unique or faced by petitioners' counsel. And the first thing I'm going to start with is the fact that most petitioners' attorneys do not have separate retainer agreements with their own clients. Typically, and because the claim petition filing itself begins the creation of the attorney-client relationship, you'll see that there might be nothing else, no other structure or agreement between petitioner and their client, attorney and their client. Now, we think it's a best practice for the petitioner's counsel to send a letter, maybe outlining some of the responsibilities of the client, certainly in being cooperative with bringing the case forward, and certainly explaining that the fee structure is going to be set by the judge of compensation. The only way out of a case, if you're a petitioner's counsel, is by substitution, and it does require a judge's approval if the petitioner is going to become pro se, and that's because the courts do not want to have to deal with pro se petitioners, and the judge will try to help facilitate the assignment of a new attorney. Client contact. Now, the rules of professional conduct require that the petitioner be kept reasonably informed against the progress of their case, and the lawyer has to explain their options to them. Okay, this is super important. And this is what I have to remind opposing counsel about all the time. I can't tell you how many times I make a settlement offer to opposing counsel and say, look, your case is not good. I'm going to offer you $3,000, Section 20, for a lump sum dismissal. Please take the money and run away and do not come back, because I'm only offering you this money because my next step is I have to go get a permanency evaluation with an IME doctor, and I've got to jump through some hoops, and I don't want to do it. So take this $3,000 and run. And I've had opposing counsel actually say to me, well, Greg, that's an insult. That number is so low, I'm not even going to bring it to my client. And I have to remind them, I have to say, wait a second, the rules of professional conduct require you to inform your own client, even about things that you don't want to inform them about, but I have now made a settlement offer. and you should please convey it to your client, right? So that's how I remind them about their ethical requirements. Another rule that impacts primarily petitioner's counsel is pre-litigation contact with opposing parties. Many of my clients get letters, usually in the medical provider claim context, that I find to be misleading. They'll send a letter to one of my clients that says something like, we're appealing the payments, you have to answer this appeal, you have 10 days to answer this appeal. And my clients actually think these are real legitimate legal proceedings or something's happening because they get scared. And really these are just demand letters that are issued by a medical provider claimant counsel to insurance carriers and employers to try to scare them into just making payments towards some of these usual and customary claims. But that falls under the grounds of pre-litigation contact. And pre-litigation contact with a unrepresented party by an attorney is something that we have to be thoughtful about, and we have to be skeptical of course, and we have to challenge this, particularly where they are representing that there is some type of legal proceeding or requirement that the employer or carrier respond to them. So I see that as a really broad area that is going to be explored further in terms of ethical violations. Now, interestingly, sometimes what is brought up by opposing counsel is this claim that the carrier stands in the shoes of the employer and defines the beneficiary of the workers' compensation policy to be the petitioner, not the employer. What this means, and where this comes into play, is where notice and knowledge has been given to the employer, the notice and knowledge is imputed to the carrier. So where we get into these problems is where the employer is communicating perhaps with petitioner's counsel or the petitioner directly about their workers' compensation case. They've never brought that knowledge forward to the carrier, and we get stuck with it because of these communications or conversations that go on. So again, that pre-litigation contact is really key. There is case law that says the carrier can't deny the coverage for a claim or that the accident happened or was work-related where the employer has already directly admitted it, particularly to the petitioner already. Contact with physicians and experts. This is an area where the petitioner's attorney is allowed to communicate directly with the treating physicians for the petitioner. Now, generally it's limited, but it does happen, and there are no rules or requirements in this jurisdiction that foreclose that. The only time where this is not true is when we come to talking about our experts. So when we hire our defense medical expert, those are protected communications right up until that expert issues their report that we intend on relying on in our case. So as a general rule of thumb in this jurisdiction, you can expect petitioner's counsel to have contact with the treating physicians, the authorized treating physician. You should also know that defense counsel and any risk professional can have direct contact with the treating physician. That's not considered an undue influence or inappropriate. But it would be really out of band and inappropriate to have communications or to attempt to persuade or interfere with or have any influence over the petitioner's IME evaluation or the defense medical evaluation. That's simply not done in this jurisdiction. Conflicts of interest can also arise for petitioner's counsel. It's generally pretty rare, although I have seen cases where petitioner's counsel attempt to represent parties where they have in the past defended that same employer. In general, this is going to be case by case, but again, relatively rare. Now, petitioner's counsel as well as respondent's counsel owe the same duty of candor towards the judge. We're not supposed to lie, and they are not either. As to material facts, a workers' compensation lawyer may not elicit or offer any evidence they know to be false or misleading, and this can result in the requirement that they withdraw as an attorney or a request for leave to withdraw as an attorney. This has become a big issue, predominantly in New York, where we see attorneys bring false claims and then seek to be substituted out of them or to abandon their clients. Happens much more rarely in New Jersey, but it does happen. All right, let's turn to ethical issues for respondents' counsel now. The first ethical issue that I'm going to talk about is absolutely the biggest issue, and it's the one that is sometimes the most challenging to navigate, and it's an issue that affects all defense counsel equally throughout the entire state of New Jersey, and that is that we are all engaged in a tripartite relationship when we represent an insurance carrier and their insured. It's the most common thing in this jurisdiction. That we would defend both the insurance carrier and their insured, but we have to be cognizant of the fact that we have two clients at the same time. We also have to be cognizant of the fact that the first master is the respondent or employer, not the insurance carrier. Of course, we owe a duty to the insurance carrier. They're our second master. We might have a long-term relationship with them, a long financial relationship with them, all those things, but my first duty is always to the employer or the insured. And court and ethics opinions are very clear on this, that my first duty is always to the employer and the insured. I went back and looked at case law, and I looked at cases going back as far back as I could find them, going back to the 40s and 50s. And so here's a little excerpt from the New Jersey Supreme Court Advisory Committee on Professional Ethics, which is, by the way, this is from the 1950s. Here it goes, quote, "When counsel, although paid by the casualty company, undertakes to represent the policyholder and files his notice of appearance, he owes to his client the assured and undeviating and single allegiance. His fealty embraces the requirement to produce in court all witnesses, fact and expert, who are available and necessary for the proper protection of the rights of his client. The canons of professional ethics make it pellucid that there are not two standards, one applying to counsel privately retained by a client, and the other to counsel paid by an insurance carrier." Now, of course, you might be looking at that and saying, wow, gendered language, how old is that? Well, that ethics opinion goes back to the 1950s. So that's how long this has been made clear in this jurisdiction, and really every other jurisdiction understands this challenge. Now, defense counsel and the insurer, although they are the payer, the right to defense is limited by their obligation to the insured, right? The insurance carrier has to do two things. One, a duty to indemnify. Two, a duty to defend. My goal is to keep the insurance carrier apprised of what's developing in the litigation. I'm trying to minimize cost as much as I can and maximize settlement opportunities. I have to always provide accurate counsel to everyone. And this includes a duty of self-abnegation, which means I need to put my client's interests, whether that's the carrier or the insured or both, always ahead of my own. You should also know in this jurisdiction, the workers' compensation insurance carrier can settle claims without the consent or even the really communication with the insured sometimes. And again, sometimes for expediency reasons, the insurance carrier will be the one directing and authorizing settlement negotiations and approving a final settlement amount. In regards to the settlement of claims, the insurance company has a fiduciary obligation to its insured, and while the insurer is not compelled to disregard its own interests, the interests of the insured must come first. What that really means is the insurance company has to do the right thing, and oftentimes they do. Another area this comes into play here is legal billing guidelines. Defense counsel were often asked to act in accordance with legal management guidelines. And they're called different things, and I've seen them ranging from 80-page documents with appendixes, with specificity. I mean, if I'm going to, use a court reporter, here's the court report I need to use. If I'm going to request a medical record, here's the medical record retrieval service we can use. I mean, really, really, really detailed. And then I've seen some that are 8, 9, 10 pages long that are rather short that just say, hey, here's the thou shall nots. Don't do these things. Do these things over here. Now, these are an attempt to control cost in general. They're an attempt to make sure that we're not wasting time, money, blood, and treasure going on adventures or pursuing avenues that will not be successful for the defense or lead to a resolution. Of course, this can be problematic as it might limit my ability to vigorously defend a case. And although in my experience it does not, of course, we have to be vigilant about that. Now, the most common area, a challenge for me personally, because I talk to clients on the phone all the day, I'm emailing everybody all the time, we're texting, is when I get questions that exceed the workers' compensation contract, right? And I think it's flattering, right? I'll get a call and it'll ask me a question about a termination or a layoff or a separation or a drug testing or something that's got nothing to do with the workers' compensation case. And I love my clients, so I try to help them as best I can. But we, sometimes are asked to jump into things or get into questions that exceed the workers' compensation context. And in that instance, because my representation of the employer is governed by usually a policy of workers' compensation insurance, I have to counsel them. I say, look, you're getting into some deep water over here, or you're asking me questions about OSHA violations of those types of things. That's not really covered by your workers' compensation policy. You need to get separate counsel for that. And when I do that, I have to put that in writing as well to make sure that 5 years from now they don't come back to me and say, well, Greg counseled me at XYZ on these OSHA violations that we were accused of. So we do limit our practice here at Lois Law Firm to workers' compensation defense. So we got to make sure that we are only giving advice about workers' compensation matters. I have the same duty of candor towards the tribunal as petitioner's counsel. Even when their case is unopposed, the defense lawyer has an obligation to make sure that the respondent's position is laid out, but also to tell the judge of any other facts that I know within my knowledge, which could allow the court to have a fully formed opinion. So that's important. Also, as a defense counsel, we're going to file a lot more pleadings, a lot more motions, a lot more certifications than opposing counsel. The reason for that is we're usually trying to get the case moving in a specific direction. If there's one annoying thing about New Jersey workers' compensation law, it is the slow speed of litigation. There's not much I can do individually to control the tempo and pace of a workers' compensation case in New Jersey. But everything I can do, I do, which is usually filing a lot of motions to try to compel discovery, compel responses, push the petitioner to get their independent medical evaluation, and push the case towards settlement. Which means we're filing a lot of pleadings, we're filing a lot of motions, we're filing a lot of certifications. Every single statement we make in a certification has to be very careful. It's being sworn to. When we assign something, we are stating that there is good grounds to support the allegations or the statements that we are making. So we need to be extremely careful here about making sure that we are providing very accurate information, typically in support of a motion or opposition to a motion for med in temp. Now, the judge can penalize us if we're not fair and accurate. Where the respondent knowingly files an incomplete or inaccurate answer, or unnecessarily delays the filing of an answer or pleading, the judge may apportion fees at the closing of case to shift additional costs to the respondent. So there are penalties for not doing these things correctly. Also, I have a duty to be in contact with and cooperate with opposing counsel. I have an ethical duty to expedite litigation. I have an ethical duty to move cases along and make sure that I'm available to communicate with opposing counsel. I am not allowed to engage in frivolous litigation adventures. And sometimes I'll get accused of going on frivolous litigation adventures to obtain information that I think is useful. I've never, ever received a sanction or had a motion denied because it was frivolous. But we need to be careful. We need to be looking for information that helps us move this case forward or creates leverage towards settlement, and not unnecessarily wasting the court time or clogging up the docket with motions that have no chance of ever being approved. Regardless, this is a jurisdiction that you do need to use your motion practice carefully in order to move cases forward and gain leverage towards settlement. So you've got to balance those things. All right, some takeaways as we reach our conclusion today. First, our role is to hold the petitioner's attorneys accountable to the rules. And we also want to represent our clients in a way that's appropriate and that they would be proud of. And so we maintain the highest ethical standards in defending workers' compensation cases here in New Jersey. So I hope you enjoyed this webinar, or if you're listening to this as a podcast, I hope it was informationally useful for you. if you're interested in learning some more things, I would recommend going to our website, loisllc.com/newsletter, signing up for our newsletter, which we're always talking about advancements and changes in the law. And we report a lot of our trial wins in there. You can also download our publications on that website as well. And if you really love workers' compensation law and want to get into some next level discussions, check out my partner Christian's podcast. His podcast is called Third Fridays, and it really is 201 level conversations and looks at developing case law. Really interesting stuff on there. You can check that out anywhere podcasts can be downloaded, or you could check out loisllc.com/podcasts. All right, thank you so much for joining me today. It was wonderful seeing you. Today is November 4th, 2024. Tomorrow is election day, and I hope your candidate prevails. Have a great day, everybody.